Hi, this is Ned Blumenthal from Weissman, and I'm here today to talk to you about some disturbing trends that we're seeing in the marketplace. Unfortunately, what we're seeing is a return of mortgage fraud. We had gone through this for a while. It went away when the economy went in a downward trend, and now, unfortunately, it's coming back. And mortgage fraud takes on a number of different shapes, sizes, and permutations, but probably the easiest way to understand mortgage fraud is to just think to yourself, is there something going on in the transaction where the lender, and by lender I don't mean the mortgage broker, I mean the actual lender and the underwriter, they don't know about it. And if they did know about it, they either wouldn't do the loan on the same terms and conditions, or they wouldn't do the loan at all. And if the answer is yes, there's something happening that the lender doesn't know about, but if the lender did know about it, they would change how they were handling the transaction. That's mortgage fraud. And you just absolutely positively need to stop everything and make sure that the actual lender is in full knowledge of what's going on. Otherwise, you're at serious risk. The charges for mortgage fraud it's a felony, so it is definitely something to be very concerned about. There have been several studies that have shown that it's very difficult, not impossible, but very difficult to practice real estate from behind prison bars, although sometimes you get your choice of black and white stripes or orange jumpsuits. But seriously, mortgage fraud is nothing to mess with. We're seeing a number of other things that are not quite mortgage fraud, but they're equally disturbing, and they're really starting to come out in like crazy numbers in the last couple of months. One of the things that we're seeing deals with unseasoned flip transactions. And these were tied to mortgage fraud, and they may be tied to mortgage fraud again, but what they are essentially is buyer number one puts a property under contract. Then before they have purchased it, before they've closed on it, they immediately turn around and remarket the property they listed, which is perfectly fine to do, but they are then getting buyer number two to sign the contract. So you have two live contracts, buyer number one buying from the seller and buyer number two buying from buyer number one. And then they will arrange, typically they will insist on using a specific closing attorney or a specific lender. They will do something with it where they want the same person involved handling the transaction. And what they will try to do is set it up where the closing with the second buyer actually happens first, so that instead of buyer number one coming up with the money to buy the property and then turning around and selling the property to buyer number two, they are essentially closing with buyer number two, and buyer number two typically is getting a loan. They're using those funds to then fund the purchase by buyer number one from the seller. And we're seeing a lot of this, and it is a significant problem. Most lenders require that the property be what's known as seasoned. Someone who's selling the property has to have owned it for a certain period of time prior to the closing. And here, what they're trying to set up is a situation where buyer number one has never owned it, and in their world, ideally would never own it. It would just flip directly from the ultimate seller to buyer number two, or if it goes through buyer number one, it'd be in their hands for maybe 5 or 10 seconds at most before the second closing. So we're seeing a lot of that. There are a couple of other issues that are out there that deal specifically with buyers and tenants. One of these issues is something called a contract for deed. And it is something that is very confusing and very confused in the law. Contracts for deed used to be somewhat typical maybe 150 years ago in Georgia. They really aren't used at all these days, but we're seeing a resurgence of them, and really nobody knows what they are or how they work. The courts certainly don't, and buyers, or folks who think that they're buyers, can get themselves in a world of hurt entering into one of these things. What happens is, instead of actually signing a purchase contract or signing a warranty deed where you get title to the property, you sign something called a contract for deed. And it's almost like an installment sales contract where you sign the paperwork and the property is purportedly yours. You're told you can move into it, you're told you have to get insurance on it, you're told you, quote, own it, unquote, except you really don't. Title still stays in the name of the seller. And you make monthly payments as if you were paying rent or as if the seller was seller financing to you. But you don't own anything. And you can be in the property, you can make improvements, you could make changes to the property, and if you miss a payment, the seller comes in and files a dispossessory action and kicks you out of the property because you're just merely a tenant. You don't own anything until you have paid it off in full, and that might take 20 or 30 years. There's another significant risk that goes along with this, and that is that because title is in the name of that seller, if something happens to them, let's say they file for bankruptcy or someone gets a judgment against them, well, that's going to impact that real estate, and it's titled in their name. So if you are the buyer on a contract for deed, you're running a substantial risk that if your seller gets a judgment against them, it's going to attach to what you think is your property. Or if they miss their own mortgage payment, they may still have a loan on the property. There could be a foreclosure, and that will impact you. So you have no rights relative to an owner, but you also have all the burdens as if you were a tenant because you're responsible for maintenance and repair of the property. And so lots of folks are presenting this as this great deal that's out there. And there may be certain circumstances where a buyer finds that this is just for them and it fits their needs, but you really need to understand what it is that you're doing, and you should really consult with an attorney before signing anything that's called a contract for deed. The other scenario we're starting to see a lot of again, and this is sort of related to that, this is a seller financing of a wraparound mortgage. What happens here is that the seller has a property and their property has an existing loan on it. The buyer comes along and doesn't have the ability to pay cash or get a loan for the full purchase price of the property. So instead the seller agrees to seller finance. Essentially, you make your payments to the seller, but the seller leaves their existing loan on the property because they can't afford to pay it off either. And so the idea is that you will make the payments to the seller, and the seller will in turn make the payments to their lender. Now, there are several risks associated with this. One, most loans these days, most mortgages, have what's called a due on sale clause in them. And what that means is that when that seller sells to you, that triggers the due on sale clause in their mortgage. So if their lender ever finds out about it, their lender could come in and call the seller's loan due and foreclose on you and wipe you out. And you have the same problems that you have with the with the deed, with the contract for deed, because there you have the same situation. If someone gets a foreclosure happening, you're going to get wiped out. If there's a judgment entered on the property, you could get wiped out, and you're beholden upon the seller to make sure that they make their mortgage payments. But you also have the burden of making sure that you keep property in good shape and repair. These are just some serious concerns that we're starting to see in the marketplace, and they're things that buyers need to be wary of, and they're things that the real estate professionals really need to be focused on and pay attention to. If something seems odd, if something seems out of the ordinary, go talk to your broker and make sure that you get clarity on what's going on, because it's just too easy to run into problems. So let's be safe out there. Again, this is Ned Blumenthal at Weissman. Thank you.